Hello and welcome to the Author Webinar Series, brought to you by the Nonfiction Authors Association and Writers Conference. Since 2010, we have helped thousands of writers learn to write, publish, and promote books that make a difference in the world. If you are seeking guidance for your own author journey and want to reach your goals faster, you can learn about membership benefits, courses, and additional resources by visiting nonfictionauthorsassociation.com. We look forward to connecting with you and hope you enjoy this webinar.
Hey everyone, welcome to the webinar series for the Nonfiction Authors Association. This one is extra special because today we're talking about business insurance coverage for authors and publishers. This is something I have wanted to bring to you for literally years. Brian and I have been working on this for over a year and a half to bring this to you. So it's really exciting. And our experts here are going to dig into what kind of insurance is out there and who needs it. Maybe you may or not need insurance. It really depends on what you're doing. So I'm going to go ahead and introduce our guests. I'm going to hand it over to them. And for those live, we are absolutely going to stay and take your questions. So feel free to pop them in the Q&A and we will address your questions at the end of, it's a brief presentation. So don't worry, we're not going to have you here for hours and hours. But let me introduce our guests. Brian Mahone is a certified insurance counselor, certified risk manager, and cyber cope insurance certification holder through Chubb and Carnegie Mellon University's Heinz College of Information Systems. Over the past decade, he has worked across sales, service, and management roles throughout Ohio, Pennsylvania, Maryland, and Delaware within the cybersecurity and property and casualty insurance sectors. Brian is the founder of Igloo Insurance, based in central Pennsylvania, where he's currently completing his MBA at Penn State Harrisburg. And Brian really helped drive this program for us today. Cooper O'Connor is a seasoned wholesale insurance broker and current vice president of professional lines at Amwins. With a decade of experience navigating complex and hard-to-place risks, Cooper specializes in management liability, technology E&O, cyber, cannabis industry risks, and a wide range of professional and management lines. Known for his technical expertise and his commitment to responsive solutions-driven service, Cooper brings deep market insight and practical approach to structuring coverage for today's evolving risk landscape. And finally, Cameron Griffiths is a highly respected commercial underwriter at CFC, where he specializes in complex commercial risks and currently leads the media, entertainment, and IP practices internationally. With a background shaped by his studies at Brunel University in London and strengthened by extensive experience within the London insurance markets, Cameron has developed a reputation for combining technical expertise with strong client-focused communication. So you all, I am so excited to bring this to you. The bottom line here is that we do have new discounted insurance options for members. Whether or not you are a member, there is valuable information to learn from this presentation today. So I appreciate you being here. Again, we'll take your questions, pop them in the Q&A. And for now, I'm going to hand the floor over to Brian and Cameron.
Awesome. Thanks so much, Stephanie. Thanks everyone for being here. We're really happy to get the program launched here. I just want to give you a brief overview of it, and then I'll hand things off to our expert here, Cameron, to talk about the nuances of the risks out there as an author or publisher. So the way we've designed the insurance program is really a create your own adventure, a Neapolitan ice cream, if you will. So the rating basis or the underwriting exposure basis really is your annual estimated revenue. So it's pretty simple: small, medium, large here on the left here, less than 250,000 in revenue, which, a lot of newer authors will be, maybe more multi-book writer in that kind of 250 to 500,000 level. And then your kind of serial entrepreneur, writer, author, publisher that could be close to $1 million in revenue. You get, I'll say, 3.5 choices of coverage, types of coverage. So that media and E&O, that's the professional liability. That's what Cameron will talk on for 10 minutes or so here in a minute. Cyber liability, and optional cyber crime add-on, and then general liability. So general liability is kind of the basic coverage here. If you're doing book signings or in-person events, someone slips and falls, that bodily injury or property damage lawsuits. And within those three categories, you can choose different coverage limits. So maybe you don't really think you need cyber, but you just want a little bit, you can get $100,000 worth. Or you really are concerned about intellectual property, maybe you do $1 million. Maybe you don't plan to do general book signings or in-person events, and you are doing everything digitally or virtually, podcasts or however you're promoting your publishing and authorship. Maybe you only get the media E&O as a cover your butt type of thing, and you skip out on cyber general liability. So it's flexible. We do estimate if you were to go to any kind of insurance market for these three coverages, you'd be spending multiple thousands of dollars per year, which is nice. We have kind of brought that to a more affordable hundreds of dollars a year. So that's the idea there. And since we have members and non-members on the call today, we do just want to briefly mention how to apply, right? You have a membership portal through the website. It is less than 10 questions. It asks about your publications, your name and address, those types of things, if you're doing any sort of expose work. And that's really Cameron's wheelhouse. I will hand things over to Cameron and go from there.
Nice. Thanks, Brian. Good morning, afternoon, evening, everyone. Thank you so much for the warm welcome today. My name's Cameron, and I run the media and intellectual property teams here at CFC. I've been a financial lines underwriter for 13 years, but focusing on media liability for the last 8. And media is very much my passion. It's why I angled my career in this direction. So I'm really excited to be here today talking to you about content in the main. So my job today is to take you on a whistle-stop tour of media liability from an insurer's perspective, and also to walk you through the program that we've put together for you. Appreciate insurance is not the most exciting of topics, and fair play to the 60 or so of you that have decided to turn up here on a voluntary basis to listen to me. So I'll do my best to keep things short, sweet, and interesting. You can see a rough agenda for today, but there'll be plenty of time for Q&A at the end. And if you could get the next slide, please, Brian, we'll kick off. So first of all, a little bit about CFC. So CFC actually stands for Click for Cover. We're established in the late 90s and we're one of the first insurers in the game to offer a cyber insurance product. Our attention swiftly turned to technology and media clients thereafter. Kind of being on the emerging end of risk is very much our bread and butter. We've now been underwriting media businesses for almost 25 years. We recently hit a really important milestone to me, as we currently provide insurance policies to over 10,000 media customers globally. And crucially for this audience, 25% of these are publishers of all kinds, ranging from small one-person band, self-publishing authors and YouTubers, all the way through to international news publishers. So we've got the full spectrum of experience. We're one of, if not the biggest media teams in the insurance market, with 14 dedicated underwriters exclusively underwriting media insurance, and we stick to a stringent 24-hour service level agreement. I'm sure right now you're probably thinking, this is all very interesting, Cameron, but what does a media insurance policy actually do? Well, have no fear. On the next slide, I will begin to unpack that for you. So, when you purchase our media liability insurance policy, you're buying coverage for legal defense in the event a third party makes a claim against you for a variety of perils, which I'll go through in a moment. This defense will include the costs to defend the claims, that's the legal costs, as well as any compensation that's due to the claimant, either as a result of a court judgment or in order to settle a claim commercially before it escalates all the way to litigation. One concept that's worth remembering is that the policy is a shield and not a sword. And what that means is that it is there to defend you if you are pursued by a third party, as opposed to paying costs for you to pursue others if you believe them to be infringing, which is quite a different kettle of fish pursuit cover. The core coverage we're providing is broken down into two sections, which I'll briefly go through here. So at the top, which is probably the most pertinent to most of the audience on the call here, you have the pure media liability covers. So that is intellectual property infringement. That would be an allegation that you're using third-party material that you don't have permission to. For example, using an image in a publication you don't have the rights to. Next, you have defamation. So that's the allegation that you say or publish something that harms a third party's reputation. For example, in the recent Johnny Depp versus Amber Heard case, where Amber wrote an article describing her experience of her marriage, which Johnny Depp took strong issue with. And finally, you've got invasion of privacy rights, which is often closely linked to defamation. And that's an allegation of you disclosing private facts about someone that breaches their right to privacy. The next kind of core section, errors and omissions, which is sometimes referred to as professional liability. This concerns itself more with a third party suffering a financial loss as a result of a service or advice you provide or content you've published. So a good way of thinking about this is if your publication includes an instructional aspect to it. So for example, if it's self-help or providing some financial advice, if someone follows this advice and suffers a loss and they bring a claim against you for it, this is the section of the policy where that claim would be defended. I won't go through each subheading in detail, but some particular highlights to point out under this section that would be interesting for you is that we include cover for subcontractors' vicarious liability. So if you've utilized like a graphic designer or a third-party writer and kind of producing your final publication, that's where that extension would be. We also provide cover for contingent bodily injury. So if you're publishing content in the health and well-being space, for example, if someone follows your advice and hurts themselves, the policy would respond in this area. Next slide, please, Brian, if you can. Now, before we get into some claims examples, I just wanted to briefly zoom into some of the complexities that we as underwriters are considering when we're reviewing a submission for coverage, as I think it highlights some of the challenges that self-publishing authors can run into. I think it's also really important to note that as an insurer, we don't for a second expect all customers to be experts in all areas of media law. Candidly, we wouldn't write much business if we did. But as a rule, we are looking for a level of risk management that's proportionate to the level of risk that is being brought to the table by a particular customer. But in the majority of cases, this threshold is really, really easy to meet, as you will see by the acceptance criteria at the end of the deck. So in this slide, I'm just trying to highlight that as well as the financial burden of a claim, one of the main benefits of purchasing a policy is actually in the expertise that we bring to the table in managing litigation in arguably one of the most complex areas of law. As I mentioned, simplistically, IP refers to publishing or reproducing third-party works without permission. This can take many formats, ranging from infringing on an established trademark, like using Coke in a publication, to a full allegation of plagiarism. So you publish something that someone thinks is line by line the same thing as they published. Infringement applies to a huge variety of formats, such as text, images, music, and video. One thing I think could be particularly interesting for non-fiction authors is that data in itself actually can't be copyrighted, but the creative presentation of data or the original collection of it in a novel way can be, and it's particularly prevalent in non-fiction and in academia. IP is a wildly complicated area of law, especially with the increasing prevalence of AI, which as yet has very limited case law or regulatory guidance. There's a number of defenses that can be utilized, and we see these claims such as relying on fair use doctrine. So there's certain circumstances where you don't need permission to use third-party material, or you could be relying on the concept of parody. The important message is that regardless of the nature of an allegation or defenses, a media policy will act in your defense and identify the best course of action in the event of an incident. I'm sure everyone on the line is aware that the US has some of the strongest freedom of speech protections globally, which makes it a great landscape for content creators and publishers. But whilst the First Amendment protects speech, publishers of content must still take reasonable care not to be reckless in what they are publishing. And this is a legal concept that is true internationally because, as Stephanie referenced, this is a worldwide offering that we're putting up today. Similar to IP, there are a number of concepts that can be utilized in defending a claim, such as arguments around like opinion or satire. You were using hyperbole, or you might have an argument that it's public interest or something that's newsworthy, so you have the right to publish it. As you can see from the little fact of the day at the bottom, cost to defend defamation claims can be substantial. Defamation claims are responsible for 4% of my claims frequency, but almost 20% of the claims costs. There's a number of drivers for this. The lawyers in that space are very expensive. Also, defamation claims are normally based on a really emotive subject. So typically kind of commercial negotiations are taken off the table because people want their day in court. They want to be exonerated. I also mentioned in the previous slide that invasion of privacy relates to the public disclosure of private facts, but even this isn't clear cut. You have legal concepts such as false light, which is portraying someone in a way that's misleading to their true character, and appropriation, which is where you're commercially benefiting from someone else's kind of name, image, or likeness. There's also a sliding scale in terms of the category of person you are and how much privacy you're entitled to. So, for example, a private individual has more of a right of privacy than a public figure such as a celebrity or a politician. When underwriters are reviewing submissions for authors and publishers, they're holding this context in mind, making an assessment based on kind of the genre and tone of the content, how broad the audience is, and how well a potential customer manages that risks. With all that in mind, a slick process like this program is relatively unheard of, so I really hope you see some value in it. If we skip to the next slide, I'd love to bring this to life for you with some real world claims examples from the world of literature, TV, and film. So from left to right, first up we have the Da Vinci Code. In 2006, Dan Brown was pursued but successfully defended a claim for copyright infringement in the UK from two authors who wrote a book called The Holy Blood and the Holy Grail in 1982. There was a similar claim in the US from the author of a book called Daughter of God. What's interesting is that both of these allegations were based around the premise that Mary Magdalene's bloodline survived to the modern day. Dan Brown had both suits dismissed, with the judge finding that you can't copyright kind of historical anecdotes or conjecture. But the UK action is estimated to have cost £1.3 million alone, which goes to show the cost implication in the event that an allegation is ultimately found to be false. Next one is Baby Reindeer, the smash Netflix hit from 2025. It's a live case being widely reported in the press. In a nutshell, the production marketed itself as being a true story, with the alleged antagonist quickly identified online. She then proceeded to be interviewed on Piers Morgan, which is a fascinating watch if you haven't seen it. And this individual is currently in the process of suing Netflix for 170 million for a combination of defamation and privacy violations. And the last two on the right, this is actually a 2-for-1 to do with 50 Shades of Grey and Twilight. So I'm actually old enough to remember the buzz around the 50 Shades first publication, and all anyone was really talking about, there's this factoid about how 50 Shades of Grey began its life as Twilight fan fiction. I thought this is a really good example of kind of fair use in practice, because in its original form, 50 Shades of Grey, the two main characters were based on Edward Cullen and Bella from the novel and the movie, and they even had the same name. But in spite of this, there's actually never been a lawsuit or a public agreement between these two authors, because E.L. James made enough tweaks to her publication prior to it being published for it to be classed as legally transformative, so it wasn't an infringing work. This has never been borne out in court, but suffice to say, if it was, the cost would be astronomical for both parties, regardless of the outcome. Now, on the next slide, I've got some more relatable examples, but a quick disclaimer, first of all. Naturally, these examples are illustrative in nature, and any particular claim scenario would be based on the specific facts and terms and conditions of the policy at the time. However, these are all plausible scenarios that I would expect to see bear out across the portfolio. So the first example I've got on the left-hand side is for an academic and a psychologist who is an expert in criminology. Say they publish a work where they're analysing the psychology of a convicted criminal, many of whom are high profile and are still living. In one of these case studies, the individual that is being analysed gets wind of it and decides to pursue the author for the publication, claiming defamation, invasion of privacy, and emotional distress. Now, in a scenario like this, all of the information is in the public domain, and the academic's well credentialed to give his professional opinion on the facts that are publicly known. So there isn't much merit to a claim like this. However, the cost for something of this ilk can easily reach the six-figure mark, In the top right, the textbook image refers to a scenario where you might have an educational publisher that's historically worked closely with another educational publisher, and they're both publishing similar revision material but working collaboratively for a particular syllabus like your GCSEs in the UK, it could be the SATs in the US. The two firms decide to sever their commercial relationship, and it's very common for then the rejected firm to bring a claim against the original firm for copyright infringement based on the similarity of their materials. But even though both suppliers are organically addressing the same subject matter, claims of this ilk often do incur substantial costs in defending them, whether there's merit to it or not. Finally, the UFO example. No tinfoil hat today. I'll remember to bring props next time. But this example relates to an author who's utilizing maybe a fairly generic sci-fi or fantasy concept, but with a story set in a particularly niche environment. So imagine an alien family, but based in American suburbia, or vampires living as roommates in New York, or something of that. So once a comic book starts to gain traction and is noticed by another author that might have kind of a similar work in a similar vein, it's very common for the one author to bring a claim against the other, claiming copyright infringement, loss of profits, and again, These are scenarios that would be defended regardless of whether there's any merit to like the infringement or not. So what I'm trying to illustrate is that regardless of the size of the customer, their pedigree, or the complexity of a claim, I think the implications can be really meaningful. In the absence of an insurance policy, the consequences can be truly severe for an individual. Now, I mentioned at the start of the presentation that CSC are pioneers when it comes to cyber insurance. So when we pulled this program together, it felt only right to include coverage for cyber options. So as a business, CFC have made the active decision to pivot our business model from a duty to pay to a duty to protect model. This means that as well as paying for costs to get businesses back on their feet in the event they suffer a cyber loss, we're also committed to attempting to prevent an incident from happening in the first instance. And we do this by providing a host of proactive services, which you can see in the headlines there, which are critically acclaimed. If you can go to the next slide, please, Brian. The easiest way to receive this benefit in full is by accessing our award-winning Response app, which every CFC customer gets access to from the moment they bind a policy that has cyber insurance attached to it with us. This slide gives a bit more detail on how our proactive services operate. So it's all a bit James Bond, but we draw data from 4 separate sources that enable us to assess in real time whether an entity we insure has any network security vulnerabilities. We partner with a number of kind of third-party private companies as well as governments. We also use our own expansive claims data. We are scraping the dark web for intel on particular threats or businesses on a consistent basis. And we also undertake kind of passive real-time scanning of the networks of insureds that we have on the books. If we identify any vulnerabilities, we notify a customer via the app, and we provide support in plugging any gaps that we find in the network security. The app also has quite a few fun features, so you can notify cyber claims instantly. There's an Ask the Expert function if you wanted to be proactive and ask about what's best practices, if you've got any concerns about your own network hygiene. You can also run things like phishing simulation. There's cyber training on there. And we've found this is particularly meaningful for kind of one-person bans, micro, small SMEs and entities who are very unlikely to be able to afford to have a robust network security kind of provider or hygiene themselves. We think it adds a lot of value to our customers. Now, finally, for the last slide, and then we will open the floor to the Q&A. Here you will see the statement of fact. We'll be asking any potential customers to subscribe to in order to access the program. There is also a corresponding claims declaration before anyone gets too excited, however. As Brian mentioned at the top of the show, the entire application process is less than 10 questions, and 3 of those are actually for you to choose what coverage options you're looking to take up. I suspect the benefit that will provide you the most value will be the exclusive rates that we're offering. But on top of this, we're offering a modular package that will enable you to self-serve based on your specific needs. We have a general liability option or public liability, depending on your jurisdiction, which, as Brian mentioned, it would be brought into the fore if you've got any kind of like in-person book signings, keynote speakers, events, that sort of thing for slips and trips and bodily injury issues. We provide coverage on a worldwide basis as standard, as naturally when you're publishing content, particularly online, but also in the physical form, a claim can come from any jurisdiction throughout the world. And lastly, but arguably most importantly, it's an easy claim to make, but we're pretty ruthless in adhering to our service metrics. Over the last year, over 92% of inquiries we've received, we turn around within 24 hours, and we apply this same logic to any changes or amendments that you may need midterm. If there is anything that you need, if you decide to take up this exciting program, please do give Brian a call. That's it from me on the prepped content. I hope that was helpful and or interesting, but now we've got plenty of time for questions if anyone has any. Thank you very much.
Fantastic. Well done, Cameron. Brian, if we can go ahead and there we go. Stop the share and open up for questions. If you have questions, great presentation, guys. I thought that was very great examples. Let's go ahead and dig into some of these questions. If you have them, please pop them in the Q&A. CL asks, what type of insurance protects you from liability for in-person or online classes based on your book's content?
A media liability policy would do that for you. I don't want to get too technical, but our definition of media content is all-encompassing. It's like text, book, film, and we actually have an ever-expanding portfolio of things like social media influencers, bloggers, vloggers, online platforms. So all of the concepts that I just spoke to you about in the context of kind of authors, they equally apply to influencers, whatever format you are utilizing to get your content out into the world.
So is that the E&O policy?
Yeah, like a media liability and an E&O policy, if it's virtual, the general liability might be less important for you, but you could still benefit from all the coverage I was just talking about under a media liability E&O policy.
That's great. And because I think we have a lot of authors who are also teaching, coaching, doing those kinds of things. So that's an umbrella for all of it. That's great. And along those same lines, Liz says, I'm writing coaching families dealing with addiction, and they create boundaries that they believe could potentially result in overdose or even death. Does she have a liability there if the boundaries she's helping them set, they think lead to?
Quite possibly, that would be quite a complex scenario to play out in real life, because there would be a delineation in most cases between the content that you're publishing and anything that you're doing as an individual practitioner. Depending on the extent of what work you're doing, in most jurisdictions, it would be compulsory for you to hold a medical malpractice or similar policy if you're giving like active like medical treatments and things of that ilk. Whereas if you're like publishing a story about that or talking about it on a YouTube channel or something like that, that's a slightly different exposure profile. There is certainly a potential liability there. When I talked about the bodily injury at kind of the top of the slideshow, that would be something that is contingent bodily injury, property damage, if it's as a result of kind of content that you publish or advice that you provide. So there is some scope there for sure.
And I think I know the answer to this one. Terry says, does this insurance cover podcasting?
It certainly does, Terry. We love a podcast.
Good question here. Dinah asks, is coverage retroactive to content published before the insurance was in place?
So it's going to be retro inception to start with. So that's the date that you purchase coverage. That's kind of the off the shelf boxed version that we've got. However, we will be taking referrals for like more sophisticated coverage needs. So if you had historical publications that you would like kind of coverage backdated for, it's something that we would consider. It would be a more manual underwrite process as opposed to like the self-serve option that Brian was referencing, but certainly something that we would entertain and do lots of.
Carl says, have you ever had to caution your clients about activities they're engaging in that approaches gray or insurable realms? How does an author or publisher know when they're getting close to crossing a line and making themselves more vulnerable to litigation?
To be honest with you, like my sentiments on this are that underwriters are not there to be dictating to our customers how they should be running their businesses. We will make a determination on a risk based on what is presented to us. So we will consider the content and the audience and the risk management that's applied, and on that basis kind of make an offer that we are comfortable with. As a result of that, we're not really in a position we can kind of inform and best practices, but we wouldn't be in a position to kind of midterm during a policy period get wind that something is going on and then say, oh, I think you're getting a bit too close to the knuckle on that. If there was something that we were concerned about that could come within the scope of your business model, it's incumbent on us to be asking those questions up front. Once we've accepted the risk, unless it's materially different to what you've provided your insurer, my view is that it would be something that like you would have a conversation about possibly at the next renewal if there was something that you saw you're uncomfortable with.
I think it would also be wise if you have any question about crossing a line of liability, you should be consulting with the publishing industry attorney prior to anything to do with insurance. Prior to publishing a book, prior to anything really, you would want to run that by an attorney, which is a nice segue because we have an attorney in the house. Denise is online. She says, I'm a literary attorney with many clients interested in coverage, wondering about pre-publication reviews. Do you require an author to obtain a pre-publication letter from an attorney evaluating risk as part of the application process?
In a nutshell, it very much depends. If there was something that was particularly spicy, you were doing an investigative expose publication about a really high profile individual, then quite possibly, yes, we would. That would again be something that's underwritten manually outside of the scope of the program. The program's got investigative expose on the statement of fact. There is going to be, I think, an expose exclusion that is applied at baseline just to badge up with that declaration on the statement of fact. But we will consider lifting that exclusion pending a more manual like underwriting process. Yet the pre-publication kind of clearance and vetting, we see it all the time in the publication world, the TV and film world. Sometimes it's a hard requirement. It does just depend on what it is. I think it would be anti-commercial if you expected like an educational publisher to be getting their manuscript cleared before publication, whereas in some situations it would be appropriate. So that's my view.
And then the follow-up question to that is, what is the definition of expose or investigative?
That would be if you're testing me now off the top of my head, but it's something around bringing new facts to light that weren't already within the public domain, something of that ilk.
Interesting. Okay. I don't know if you can answer this. Fred asks, how many claims have been paid out in the last year?
Not explicitly. We actually were doing some analytics recently. We've paid we've seen approaching 1,000 notifications over the past kind of 4 or 5 years, of which many of them were paid out. We have a 93% claims acceptance rate on the portfolio. And of the small kind of threshold that weren't accepted, it was because of things that were like kind of a misunderstanding of the policy, like the pursuit scenario that I referenced earlier, or something of that ilk.
93% sounds very high. So Carol asks, can you give an idea of cost range of costs for different insurance options? I think you guys said hundreds a year, right?
Yeah, I can take that question. I mean, a bare bones small limits, maybe one of the 3 coverages is going to be about $500 for the year. And if you max out all 3 coverage, it's going to be about $2,000 for the year. So in that range, depending on what they choose and how big they are.
And what I appreciate about these guys is you can tell they're very authentic. They're not going to oversell you. So I think you're going to feel very confident that what they deliver to you is what you actually need. They're not going to try to sell you what you don't need. Pat says, should authors put something on their website to protect themselves, not necessarily a warning, but an indication to someone who might want to use material on the author's website? That's more of a disclaimer question for one of the attorneys, I would say. That's not an insurance question. Adam says, Cameron, regarding proactive app, you're scanning the dark web, etc. Sounds more like a sword than a shield. Most issues will be brought to your attention. What are you preventing? Cyber security, for those wondering.
Yeah. On the cyber side, I know I said that it's a shield, not a sword for the media liability, but cyber does include like first-party coverages as well as third-party coverages that will pay for like your instant response costs that you incur as opposed to someone having to sue you if you do see an incident. And we're protecting against, we've got lived examples of getting intel that a particular threat actor group is looking to target potentially like a particular segment of our portfolio. So say, oh, we're targeting manufacturers of this size. They're talking on the dark web about a particular insured that we know of that's on our portfolio. So we're kind of sending a notification to them to say, people are talking about you. This is the vulnerability that they're looking to exploit. This is what we suggest you put in place so that you can prevent that incident from happening in the first instance, is how it works in practice.
Great. If you're a consultant who also publishes content, does this insurance also cover the consulting side, which is typically spoken guidance, advice, follow-up emails, and documents?
It could do. It depends on the type of consultancy that you're doing. Because it's a media and entertainment portfolio, it needs to be creative or creative adjacent consultancy. So if you're like doing some marketing consulting and also publishing marketing books, absolutely. If not, it might be something that we would have to speak to another team within the business about. So if you, in the example that you referenced earlier, you were doing like healthcare treatments, we might do the kind of a publication aspect of that, but then we would ask our healthcare team to look at the direct treatment aspect. So we would collaborate in that way, but potentially.
Denise, the attorney, asks, do you have figures for infringement-based actions versus defamation-based actions?
So I did have that little tidbit. It was 4% by claims volume and about 20% of the severity. I've got it here actually. For IP infringement, it's about 32% of the frequency and 38% of the severity. So much closer. What was interesting about defamation is there's a big range, isn't there? It's 4% of notifications, almost 20% of the costs, whereas IP is like much more closely aligned, 32 and 38.
Please let me just remind everyone, if you have questions, put them in the Q&A box, not the chat. It's hard for us to sort through that, so please put them in Q&A. CL says, if you have a personal umbrella liability policy already through another firm, would your policies provide coverage first, then the umbrella?
I don't see why it wouldn't, because we would often not know if a customer has an umbrella off the back of us anyway. Like we're interested in like the primary like upfront underwrite, and if you choose to purchase an umbrella off the back of that, then I would say that's down to the umbrella provider.
Yeah, I would say that's a topic they should probably bring up when they're applying. Working with me, Stephanie, it's possible that the umbrella needs to point to the underlying coverage. If they already have the umbrella and then they go in the program and they forget to mention it, the umbrella won't know the new policy exists unless we kind of coordinate that. So
That makes sense. Okay, Linda says, are there special considerations for memoirs?
Yes and no. Memoirs are undeniably like one of the riskier areas that would be within the scope of this program. But as long as you're comfortable with the expose kind of exclusion, then we would write them at the grid rates that Brian has referenced. If you'd like to get that lifted, then we would review the publication via a synopsis, what risk management you've applied to it, like what the tone of the content is in order to make an underwriting determination from there. Invasion of privacy, as I kind of referenced out, is a wildly complicated area of law. The first time I became aware of these sorts of scenarios, I remember reading A Child Called It when I was really young, and I was like telling all of this stuff. I'm sure that someone somewhere, if they had a different view of that, might take umbrage with it. So yeah, it's a consideration, but again, it's not something that's insurmountable or necessarily out of scope. Just might need a little bit more TLC.
And that might be an example where a letter from an attorney, would that help you guys write the policy if an attorney had vetted the manuscript?
It certainly would, but again, it wouldn't be necessary in all cases. It would depend on what the like narrative framing was, I suppose.
Okay, fair enough. When it comes to publishing contracts, the author has to indemnify the publisher if publisher is sued based on author's mistakes. Do you provide that indemnification on behalf of the author?
Yes, that is very common. So we have an additional insured extension, which means if a third party is pursued as a result of your negligence, then the policy will respond as if that third party was you, if that makes any sense. So it's explicitly there to deal, it's got a mechanism explicitly for that scenario. And to be honest, it's a big driver of inquiries for the portfolio as a whole, like contractually driven. I need to purchase this to get it published over here or to fulfill this contract. So
this is another legal question, but maybe you guys want to answer. Dan says, my book takes place 250 years ago. Can ancestors of the characters I depict sue for defamation or invasion of privacy?
I would refer that to the lawyer, but I would say it
Yeah,
depends.
I would say yes, and I'm not an attorney, but I'm pretty sure the attorneys would say yes. You definitely have to worry about descendants as well.
my take would be anybody could.
Yes. Well, yeah, anyone related. Did we get them all, you guys? I'm just searching through the chat real quick. I already have a case of plagiarism, but in Israel. Can you file a case anywhere? So this isn't a proactive go after someone else. This is protecting you if someone's coming after you, just to be clear. My understanding is that all URLs are considered public domain and can be used in one's content. If the owner of a URL objects to yeah, that is absolutely not true, Stan. You cannot copy information off the internet. That is 100% violation of copyright. Please do not do that. That is not true at all. So yeah, that is not true at all. If you pull an image off another website or copy text, that is a 100% a violation. That is how you end up getting sued and getting fined. What else? What is the company's AM Best rating? Fred asks. I don't know what that is.
So we are a Lloyd's-backed managing general agent. AM Best, I believe, is A+. Well, you'll be able to find that on our website if you search CFC capacity.
Susan says, I've written a memoir. Do I have to get permission from people whom I've named in my memoir, or does your insurance cover me if they object to their real names being published? People involved are high profile. For example, Jane Priest, who kissed Prince Charles, Western Australia Beach, and David Bowie. That's some liability stuff right there, Susan.
That
I'm
would
no
fall
attorney.
outside of the program.
Yeah, you need to meet with an attorney, Susan. That is, I would definitely not advise that you use people's real names without their permission. If all my books are sharing my own experience on focused topics, what issues do I need to be concerned about? What concerns do I need to be aware of participating in an anthology of my experience on a topic? I
If it
mean,
was your
that's free
own,
speech, right? That's you have a right to share your personal experiences.
yeah, if it's your own, it gets dicey when you're bringing third parties into it, and that's when potentially an attorney could inform you on anonymizing it in some way or shifting things so that someone's not directly identifiable while still kind of telling the same story that you would like to tell.
All right, I think we did it, you guys. This was fantastic. Thank you so much for your time. I'm just going to remind our listeners that you can get access to this discounted program through the member portal. And if you're not a member, I'm popping in the link. Feel free to join us. And that will give you the instructions on how to get in contact with Brian, who's leading the charge on this program. But I hope you learned a lot. I did. I learned a lot today as well. And just appreciate you guys so much. I'm so excited to finally bring this program to our community. I think it's really important. So thank you so much.
Yeah, you're very welcome.
Awesome. Thanks for your time, everyone. I enjoyed that.
Thanks,
Yeah.
everyone. Recording will be
Thank you.
shared later today. We appreciate you all. Have a great rest of your day.
Thank you for attending this webinar by the Nonfiction Authors Association. Since 2010, we have helped thousands of writers learn to write, publish, and promote books that make a difference in the world. If you need support navigating the complexities of the publishing industry and want to reach your author goals faster, you can learn about membership benefits, courses, and additional resources by visiting nonfictionauthorsassociation.com.